the September 30th deadline of 2026, where those EB-5 investors who file by this date are eligible to be grandfathered in, meaning you get grandfathering protection, a protection from any future legislative changes. Also, if the program expires next year at its sunset and is not renewed, those of you who filed your petitions by September 30th this year are protected, grandfathered in. So as a result, I'm getting a lot of requests about how do I actually file my petition by September 30th, because typically we say it does take 1 to 3 months to prepare this petition. And now we have less than 50 days left. So how do we get this done? So first, I would say, yes, it is still absolutely possible to start your EB-5 process today and complete your filing by September 30th. However, that will depend on your individual case. So this video is to help you guys and give you some resources. Please keep in mind that although I am an attorney and I am a licensed FINRA investment professional, I am not giving you legal advice and I'm not giving you investment advice through these videos. These are just helpful tools which you then should be discussing with your individual immigration attorney and your investment broker that you're choosing to work with. If you do need assistance from a professional investment broker and you want to utilize me, you're free to reach out and schedule a consultation. If you're using another broker, that's great, and make sure they are aware of your specific facts so you can build a plan to file your petition with them. So, but how do you actually get it done? When I was a practicing attorney, we used to file over 100 cases per year, EB-5 cases. As the partner of the firm, it was my job to lead my team and make sure things were getting done timely. So, and we used to have quite a bit of these deadlines because we didn't even have grandfathering protection. So every time the program would expire, we didn't know if it was going to get renewed or not. And so a lot of people tended to want to file by September 30th every year. So I've gone through a number of these deadlines, and out of 100 or so cases that we would file every year, probably 70% of those cases came in August and September. So this is how I would recommend to implement the procedure to make sure your filing is done timely. First, you need to have a discussion with your immigration attorney, because the main part of this process that truly takes a lot of time is your individual documentation for the source of funds. I would not recommend filing what's called a skeleton filing. That's when you just file the bare minimum documents, thinking that USCIS is going to send you a request for evidence. That is not the practice anymore. Immigration, if they see that you have filed your petition without any substantive evidence to confirm your lawful source of funds, they often will not send a request for evidence and will not send a notice of intent to deny. They will often send a straightaway a denial. So a skeleton filing, as we call them in the industry, is not an option. So first, you need how to prepare is you need to have a sit down with your immigration attorney and have a clear understanding whether their specific team is able to work with your specific documents and finish them on time. My recommendation is that you draft out an outline that ends on September 15th, right? Because that gives you a couple of weeks for things that were not anticipated, delays, and so on. But your goal should be to have your petition prepped and ready to be sent out on September 15th, right? And then you work your way backwards. You literally write out dates saying, okay, today is August 11th. So what do you, immigration attorney, need from me by August 13th? Which initial documents? Do you need my source of funds story? Do you need my bank documents? What documents do you need from me in 2 days? What action are you going to take on these documents? How many days you need to review it? And so on. So you kind of work your way back, like what has to get done by September 10th in order for you to have my petition ready, what has to be done by September 5th, what has to be done by, August 29th. And that gives you markers, because overall you will need to present your story, how you made your money or how it got transferred to you. You will need to present supporting documents to your immigration attorney. and they have to be translated. Fortunately, with AI now, there are a lot of companies that are available to do expedited translations. Your attorney will have to review those documents, make sure they understand them, they cross-reference them, and they will need to have the opportunity to ask you for additional clarifying documents if they find that the original package that you gave them didn't contain all the necessary information, right? So all these steps take some time. And that's why sit down with your attorney and write out a plan, going back, working your way back from like September 15th backward. If you're also filing a concurrent adjustment, that's a separate set of documents, right? Remember, for concurrent adjustment, you usually need to do medical exams. Those need to be scheduled, and not every location has availability within a week or two. Some locations you have to wait for a month or 6 weeks. So if you are doing a concurrent adjustment, I recommend scheduling your medical appointment sooner than later and figuring out what other documents you may need, such as birth certificates and so on. So you have your list of financial documents, your dates when you provide them to your attorney, your dates when the attorney has to review it and come back to you with comments, so you can provide additional documents, right? And give them enough time to then review the final. Then you have your biographical, especially if you're doing an adjustment of status. You schedule your medical exams and figure out when those documents have to be presented, so the legal team has enough time to put together the package. Now, it is also important to understand that if you're in the United States and you're filing your I-526E petition, if you want to avail yourself of the grandfathering protection, just your I-526E has to be filed before September 30th. If you also want to do a concurrent adjustment, your concurrent adjustment doesn't have to be filed the same time. You can just file the I-526E and file your concurrent adjustment later. So if there's a delay in documents for your concurrent adjustment petition, you can file it after the I-526E, and that doesn't jeopardize your grandfathering protection under the EB-5 program, right? Because you can also just file the I-526E and do consular processing. So that's one way to save time. Don't try to bunch everything in. If there's not enough time to prepare your lawful source of funds documents for the I-526E filing and to also do your adjustment application, then discuss with your immigration attorney filing the adjustment later. Now, please discuss this with your immigration attorney, because whether or not you're eligible for concurrent adjustment, what are your timelines, when does your current non-immigrant status expire, all of those are very individual questions that your attorney has to look at your set of facts. Whether or not you're eligible, whether it's advisable to be filing an adjustment, and whether or not it has to come together with the I-526E or can be filed later. Keep in mind that if you are filing the concurrent adjustment after the I-526E filing, generally there's going to be a few weeks gap, because the I-526E has to be filed, and then you will have to, if you're not filing the adjustment concurrently, but you're filing it a few weeks later, then you actually have to wait for the I-526E receipt to arrive, because you need the I-526E number, case number that was assigned to it, in order to file an adjustment based on that case number. So you either have to file them concurrently in one package. If they're not going out in one package, there's going to be a gap of time where you have to wait for the receipt number from the I-526E. But that's one strategy, that if you don't think there's enough time to prepare both the adjustment and the I-526E, just file a quality I-526E, get the grandfathering protection secured, and then work on your adjustment later. Another thing that I cannot stress enough, if you're just now starting to look at the EB-5 program now, the project quality not only tremendously affects your chances of getting the initial and then the final green card, right? Because you need to be invested in a project and a regional center that they know what they're doing, that they're on track to create the jobs, and they will provide all the proper reporting to USCIS and hopefully not lose their license in the meantime, right? So proper project affects your green card petition. It also affects your possibility of returning your capital. All of these projects are real. you can lose your capital if you invest in something that does not succeed. Do I personally think there is sufficient time in the next 50 days to do full due diligence on multiple projects in order to make that decision? Not if you're starting from scratch, right? So if you're entering the EB-5 program now, I would recommend that you use licensed professional FINRA brokers who have already been doing EB-5 due diligence, right? So for example, my clients who are coming in today, I'm able to show them projects that we have spent months doing due diligence on, right? So I already have pre-vetted options from many different projects that we looked at. We've already reviewed their documents. We already filtered out the ones that we don't like or that we think have additional high risks for our investors. I've already done site visits on this project, so an investor can come to me today and we can jump into discussing projects that have already passed independent FINRA due diligence. And yes, 50 days is more than enough time for us to look at different options that are pre-vetted and make a selection out of those options, right? But if you're doing this yourself from scratch and you're just starting your Google searches, in my opinion, that's not enough time to do a quality project review. So if you're working with the EB-5 program now and you just discovered it and you're doing project selection, if you're trying to file by September 30th, I highly recommend using a FINRA licensed EB-5 professional broker to actually guide you to projects that have been pre-vetted by someone licensed and skilled to do so, right? Alternatively, you're just putting yourself in a situation where you may rush and place your money and your future immigration benefit into something that you may not have had time to diligently review. So use very competent attorneys, have an honest conversation about their capacity right now, because attorneys are different. Some attorneys still have capacity to take in EB-5 clients. Some attorneys are already at capacity, so they're not taking new clients anymore. Have a discussion with your immigration attorney, find an attorney that genuinely has the time to spend on your case, and we'll be able to accommodate you by September 30th, right? Make a very diligent day-by-day plan, what is expected from you, what is expected from them, and stick to that plan. Don't think that just because you handed your legal team documents on day 40 out of 50, that they're able to review it in 2 days. That's just, they have other cases, they have other responsibilities, they may have court hearings that are scheduled. So if you didn't discuss a certain date with your attorney and you're handing your documents to them on that date, then you need to give them sufficient time to review. So just kind of be mindful of that. Speak with your immigration attorneys, make a plan, use professional FINRA brokers, separate your adjustment from the I-526 filing if need be, right? They don't have to go out together. And those would be the practical steps on how to move your case along in an efficient way to still create a quality filing. Now, when it comes to specifically sourcing funds, one of the things that I would also recommend is when you're telling your story where your funds came from, write out a very detailed narrative. So explain to your attorney, this money is coming from savings. The savings are coming from salaried income from so many years from this job, and cross-reference it with bank statements, tax returns, so that the attorney has an easier time reviewing what you said and right away knowing exactly which document supports your statement. So all they're doing is just cross-referencing to make sure that it qualifies, instead of digging through dozens of pages trying to figure out which document supports your statement, right? So if you don't cross-reference your own statements with the specific document and with the specific information that this attorney can find in the document, it's just going to delay their process, right? So if I say my savings are coming, my $300,000 in savings are coming from my salary at Meta, and I just see, please see folder A, but I don't specify what's in folder A, again, it's just going to slow down because the attorney is going to open folder A, it's going to see some bank statements, some pay stubs, some tax returns, but it doesn't make a lot of sense, right? It's going to take hours for that attorney to read through it and make sense of it. Versus if you say, my savings come from Meta from 3 years, please see folder A, 3 years of tax returns showing that my salary was $250,000 a year, 3 years of bank statements showing the direct deposit of that salary into my Chase account, 3 years of savings in my brokerage showing that the money was leaving my personal Chase account and being transferred into the brokerage account, so I'm buying stocks with my savings. And that level of detail is going to enable this attorney to look at the documents and get through them in an hour or two versus an entire day. So anytime you just give more work to your attorney and have them search through documents, that's only going to impact your case at this point and the quality of your case. And I know some of you might be thinking, what am I paying the attorney for? At this point, you're paying for quality control and speed, right? You shouldn't be paying your attorney. It's not their job to do clerical work for document organization, especially if you want them to take on your case on such a short notice. But yeah, I definitely think it's very doable. When I was a practicing attorney, we were accepting new clients up to 3 weeks before the deadline. Actually, we were just extremely, like, I would interview the clients to understand if the funds are ready, liquid, and so on. I would want to make sure this client understood project selection and they had a professional assisting them with project selection. And my office, we also kind of had the capacity and the systems in place to do these filings on such short notice. That is not possible for all immigration law firms. And some immigration law firms that are very good at EB-5, they're accommodating a ridiculous amount of clients right now. So they're stretched thin in their capacity. So I wouldn't wait till the first week of September. I absolutely would reach out to an attorney, make a decision and hire your attorney, right? Also, if you talk to them today, but you don't hire them till September 1st, you might be jeopardizing your case. Now, on the project selection, the way it works, the main difference between using a professional or trying to do this yourself, when you try to find a project yourself, you're starting to Google and reach out to different regional centers. They will send you hundreds of pages of offering documents. That includes contracts, permits, proposals. Now, who on your behalf is going to read all these contracts, then cross-reference them with whether or not they actually got the permits, land entitlements, needless to say, who's going to visit the project to sort of see what's going on in the area. Versus when you come to a professional, like if I'm working with a client today, which is what we're doing over the next few weeks, when I start to work with the clients, I'm already showing them projects that we have already reviewed the contracts. We have already made sure land entitlements are there, the permits are there. We've looked at the latest economic reports to see how many jobs they've already created. So I am presenting to you, usually between 5 and 6 options that meet your needs, whatever it is, whether it's rural, 956F approved, whether you want a shorter, kind of investment timeline. I'm presenting, pre-selecting out of dozens, 5 or 6 options, and getting on the call with you to go through and share my notes from the site visit, share my pros and cons in each deal, so you can narrow down your options as to what's more suitable for you much faster. Right, so typically I, am able to assist clients within a few calls over a period of 1 to 2 weeks, because we're already focusing on pre-vetted options that have passed our due diligence, right? So utilizing a professional at this stage, I think, is very important if you want to give yourself a maximum chance of picking a suitable, qualifying project, and utilizing, obviously, professional attorneys. So I hope this was helpful. And if you guys do need any assistance, if you're looking for even attorney recommendations, please reach out. And if you're looking for professional guidance through EB-5 project selection for projects you can invest by September 30th, also let us know. Another important part is when you work with professionals, once you pick a project, we are the ones helping you to make sure you get a spot in the project, the investment documents are signed, and you have a spot ready before you wire. Because we are also seeing this as the fundraising season is coming to an end. Some of the projects are selling out. So an investor may have looked at a project a month ago, they still have spots, they liked it, they decided they're going to invest in it. Their attorney has been working on the source of funds. Now they're going to be ready to wire on September 1st, but guess what? The spots have already filled up in that project. And regional centers right now at this late stage, they can't hold your spots unless it has been pre-negotiated through your broker. So next thing you know, September 1st, you thought you had a project selection, but now you have to start over and look for a new project. So again, working with a professional, if you guys do find yourself in these situations where you thought you had a spot in the project and the project got filled up before you had a chance to wire, please reach out. Right now we have multiple projects and a few of them that will not, that will still have spots in September. So if you need last minute project selection help, we're definitely going to be available to assist and still give you options. I would never put you in something that I would not think appropriate for an investor to invest outside of a deadline. So we're not putting you in a project just because it's a deadline. It's the same quality control and the same standards that we would apply even if there was no deadline. But I am happy to say that we've been preparing for this all year to make sure that we have a number of different project options that will still have spots throughout September and will be available for investors to consider. Right? We're here to help, and for next week's live, send us suggestions on topics because I always want to address topics that are